In the development phase of an entertainment project, writers and producers should have an attachment agreement that protects both parties so that they can remain committed to the development of their project. In this third video of the attachment agreement series, I want to share 3 key elements for writers to focus on so that they don't get taken advantage of. Attachment agreements are beneficial to writers, also known as talent, because it allows them to get upfront compensation for their work on the project during the development period, while also getting the long-term security of being locked into the project when it eventually enters full production. Talent also gets flexibility in attachment agreements. They can either ask to negotiate their own deal with a third-party network studio, or they can choose to lay out the terms of their production services by finalizing their compensation, credit, and back-end. There are 3 elements of an attachment agreement that writers should focus on to protect themselves. First, writers need to focus on the lock clause. The lock clause guarantees that the writer will be locked to the project in the same manner as producer. One of the benefits of an attachment agreement for a writer is job security. The writer can enjoy the long-term benefit of being tied to the project and can feel secure knowing that the project can't move forward to production without them. So in order to obtain the ultimate goal of staying on a project once it is greenlit, talent needs to have a strong lock clause. By having this clause, the writer can be assured that they are on equal footing with the producer. If the producer is locked to the project for 2 seasons, the writer is locked to the project for 2 seasons. If the producer is locked to the project for life, the writer is locked to the project for life. The second element for talent to focus on is the services clause. This allows clarity on what services they will be rendering on the project during the development period and eventually during principal photography. A well-drafted services clause should lay out what development materials the writer will be specifically creating, such as a pitch deck or a pilot script, and whether they will be required to attend pitch meetings with the producer. After you have covered the terms of your services during the development period, you should also finalize the terms of your services in the event a network or studio picks up the project. By having a detailed services clause, the talent can be confident in their role and services in connection with the project. The third element to focus on is the control clause. Essentially, the control clause states which party will have the right to make creative, financial, and business decisions relating to the project. If you are a writer who owns the underlying script to the project, you should be wary of producers trying to pry away your rights related to the creative decisions of the project. While producers are traditionally more equipped to determine the financial and business decisions of the project, this should not mean that you, as the key writer and creator of the project, should not have any say in the future of the project. In the control clause, the talent should always ask for meaningful consultation rights over all creative decisions relating to the project. This might seem like a big demand to producers, but as a writer and creator of the project, you are really the one in the best position to give feedback to make the project more successful. As a writer, focus on these 3 elements within your attachment agreements. They will assure you of your rights and make it easier for producers and studios to work with you in the future. It will also allow you to confidently get closer to completion of your creative vision of the project. If you are a writer, I would always recommend having an attorney look at your agreements to ensure you are protected.